Welcome back to the deep dive. Our mission here is always the same, to take complex, foundational source material and just distill it into knowledge you can immediately use.
We really don't just skim the surface.
No, we dive deep. And today, we are tackling the absolute bedrock of litigation in Ethiopia, judicial jurisdiction.
And this deep dive, it's explicitly tailored for you, the third-year law student.
Yeah.
Because this isn't abstract theory. I mean, understanding jurisdiction is the difference between a successful career and, well, a series of void judgments.
Right. If the court lacks the power to hear the case, everything that follows is just. It's meaningless.
Completely meaningless.
So our goal today is to systematically and hopefully conversationally unpack the current structure of the Ethiopian judicial system, the fundamental principles that define that judicial power, and then the three big interlocking tests: judicial, material, and local jurisdiction.
And these are the tests that determine which court has the right, to speak the law in a specific case.
Exactly. But before we get into the weeds, we have to acknowledge our source material.
We absolutely do. We need to extend our sincere gratitude to the esteemed lecturer and lawyer, Mr. Abdurrahmanside, for preparing the comprehensive and, frankly, incredibly detailed lecture notes which form the authoritative basis for this whole discussion.
Yes, a huge thank you for providing such a crucial foundation for, future legal professionals.
Hear, hear.
Okay, just a quick note on scope. Mr. Abdurrahmanside's material includes a fascinating history of Ethiopian judicial power.
It does, from the 1931 Constitution all the way through the Derg era.
But in the interest of focusing intensely on the law as it operates right now, the Federal Democratic Republic of Ethiopia, or FDRE, system, we are jumping straight in.
We strongly advise you, the student, to go back and read that excellent historical background. The work by K. Ivaput, which is referenced in the material, is a great place to start.
Definitely worth the read. But for now,
time is indeed precious. Let's start with the operational framework, the dual court system established by the FDRE Constitution.
Okay, so the first thing to really get our heads around is that Ethiopia doesn't have one single unified judicial system. It has two, running in parallel. Where does the power to create these two tracks even come from?
It rests entirely on the constitutional mandate. Specifically, you're looking at Article 78 and Article 79 of the FDRE Constitution.
Okay.
These articles clearly state that judicial power is vested in courts at both the federal level and the state, or, regional level. The structure really reflects the federal nature of the Ethiopian state.
And within that dual framework, we have a uniform vertical structure. So each system has, what, 3 defined tiers?
That's exactly right. Think of it as 2 vertical ladders running side by side. The federal system starts with the foundational courts.
Yeah.
The federal first instance courts.
The FFICs?
Right, the FFICs. Then appeals from there go up to the federal high court, the FHC.
And at the top.
And topping that specific hierarchy is the federal Supreme Court, the FSC, which, as we'll see later, also plays a really special role when it comes to cassation review.
And I'm guessing the state structure pretty much mirrors that architecture, but the names might reflect local division.
You've got it. The state structure begins with the state first instance courts, which people commonly call Wareda courts.
Right.
Above them, you have the state high courts, sometimes called zonal courts, and then finally the state Supreme Court. And that acts as the ultimate judicial authority for that specific region, on state law matters, of course.
So this careful vertical distribution of power is really essential for the whole judicial flow.
It is. Now, Article 78 of the Constitution, it doesn't just establish the courts. It also protects the integrity of this entire structure.
How does it do that? What's the constitutional guardrail here?
The guardrail is an explicit and very strict prohibition against establishing what are called special or ad hoc courts.
So courts created for a temporary purpose, or maybe to just bypass the regular system.
Precisely. Article 78 makes sure that no political body can just invent a parallel justice system to handle specific, maybe controversial cases outside of that established 3-tiered framework.
That seems like a critical safeguard against, the erosion of due process, especially given some of Ethiopia's history with political courts.
That's a massive safeguard. But the Constitution also explicitly acknowledges that not all disputes fall under the purview of these state-run secular courts.
Right, Article 78.5 makes an exception, doesn't it, for other established bodies?
It does. It explicitly recognizes religious courts, like Sharia courts and customary courts, and it envisions that they'll be established and operated through specific laws. It shows the system's respect for the diverse communal mechanisms for dispute resolution.
Especially in things like personal and family law.
Exactly. They operate parallel to, but separate from, the federal and state regular courts.
This brings us to a really vital distinction for law students, the difference between a regular court and an administrative adjudicative body. The source material calls them legally empowered institutions. How are they different?
So regular courts are established under Article 78. They exercise the full constitutional power of the judiciary. These legally empowered institutions, however, are essentially administrative tribunals.
Okay.
They're delegated a sort of quasi-judicial power, usually to review or resolve disputes that arise from administrative decisions made by the executive branch. They exist completely outside the regular court hierarchy.
So they're not general courts of law, they're specialized mechanisms tied to specific pieces of legislation. Can you give us a few concrete examples?
Sure. A really prominent one is the Labor Relation Board. Its jurisdiction is spelled out in the Labor Proclamation, specifically Article 145 of Proclamation 1156/2019. It handles disputes between employers and employees.
Okay, that makes sense.
Similarly, you've got the Tax Appeal Commission under Proclamation 983/2016, which hears appeals against tax assessments. You've got the Civil Service Tribunal for disputes about civil servants' status, and the Social Security Appeal Tribunal for Social Security claims.
So the key takeaway for any litigant is this idea of exhaustion of remedies. If your dispute falls under one of these tribunals, you can't just run to a regular court.
You can't. If a regular court is approached first on a matter that's clearly meant for the Labor Board, for instance, the court will almost certainly dismiss the claim for lack of material jurisdiction. It'll force the litigant right back to the proper body.
These institutions are the gatekeepers for their specific administrative areas.
Precisely.
That sets the stage beautifully. We know who the players are. Now let's define the power itself, jurisdiction.
The term jurisdiction is, well, it's fundamental. As you mentioned earlier, it comes from the Latin juris, meaning law, and dicta, meaning speech. Literally, I speak by the law. It's a declaration of authority.
And in concrete legal terms, what does that authority actually let a court do?
It is the inherent power of courts to hear, render, and execute a binding and enforceable decision over a case. Without jurisdiction, a court is just a building. It has no legitimate authority.
This brings us right to what the source calls the power principle. If a court moves forward without this power, what is the exact legal status of its judgment?
If the court lacks jurisdiction, the decision is treated as an absolute nullity. It's called coram non judice,
Which means
before a judge without competence. It has no legal effect whatsoever. You, the law student, have to understand this difference. A judgment without jurisdiction is void. It can be challenged at any stage, even decades later. The court must dismiss the case.
Okay, so what if the court has jurisdiction, but it just gets something wrong? Say it misinterprets the evidence or applies the wrong article of the Civil Code.
And that is the critical distinction. It's the difference between a want of jurisdiction and an irregular exercise of it. If the court has the power, but just uses that power incorrectly, the judgment is not void.
So it's not a nullity.
Not at all. It's merely voidable. It means it can be appealed and reversed by a higher court, but it stays binding until it's successfully overturned. The appeal is about the merits, not the fundamental lack of power.
That distinction is just paramount for appellate practice. A lawyer challenging a judgment for want of jurisdiction is attacking the very foundation of the court's authority.
Exactly. Whereas challenging an irregular exercise is just arguing the court used its power wrongly. One voids the result, the other asks for a do-over. This leads to this inherent power that civil courts have, the jurisdiction to determine jurisdiction.
Explain that power. What does that mean?
It means a court is inherently empowered to decide the question of its own jurisdiction. If the defendant raises an objection, the court doesn't just stop. It has to conduct a preliminary inquiry, hear evidence, hear arguments, just to resolve that jurisdictional question first.
So it can spend weeks just investigating whether it's competent, even if it ends up deciding it isn't.
Yes, the very act of determining its own competence is itself a competent judicial function.
Okay, let's quickly nail down the general principles for civil courts. These are non-negotiable foundations for this whole area of law.
First, the presumption is broad. A civil court has jurisdiction over all suits of a civil nature, unless that's expressly or impliedly barred by law. Second, and this is huge for tactical reasons, consent can neither confer nor take away jurisdiction.
Why is that second point so important?
It maintains the sanctity of the legal hierarchy. I mean, if jurisdiction was just something parties could agree on, the whole vertical structure, Warvada, High Court, Supreme Court, and the horizontal split between federal and state would just collapse. Jurisdiction has to be determined by law, not by negotiation.
And what determines the facts for jurisdiction, the plaintiff's claim or the defendant's response?
It generally depends on the allegations in the plaintiff's statement of claim. The defense's arguments don't typically determine jurisdiction, except maybe for a counterclaim. And finally, you have to remember that any law trying to oust a court's jurisdiction must be construed very, very strictly.
So once we establish these general principles, the inquiry breaks down into three necessary components. A court has to satisfy all three to proceed. What are the three pillars?
They are: 1, judicial jurisdiction, which is the state's power over the person or property; 2, material jurisdiction, which is the court's power over the subject matter; and 3, local jurisdiction, which is the court's territorial power.
Okay, let's start with judicial jurisdiction. This feels like the broadest test, the big international gateway question. Does Ethiopia, as a sovereign state, have the legal competence to subject a foreign person or foreign property to its courts?
Right. And this specific inquiry only gets triggered when there is a foreign element. If both parties are Ethiopian nationals, they're domiciled here, the case arose here. Well, judicial jurisdiction is just assumed. We jump straight to material jurisdiction.
But if a party is a foreigner or the deal was made outside Ethiopia, then this issue comes up.
It does. And it matters so much because of enforcement.
How so?
Well, if an Ethiopian court issues a judgment against, say, a German company, that judgment is only useful if it can be recognized and enforced in Germany. And a German court, following principles of private international law, is first going to check if the Ethiopian court had valid judicial jurisdiction in the first place.
Which is where the gap in Ethiopian law becomes a serious problem. The source material highlights that there is no specific Ethiopian law explicitly governing judicial jurisdiction. That sounds like a profound legislative hole.
It creates significant uncertainty. And it's exactly why the Federal Supreme Court Cassation Division, the FSCD, has had to step in and create law through its jurisprudence.
So how do courts navigate this?
When an objection to judicial jurisdiction is raised, the court has to rely on general principles from foreign legal systems, Ethiopian court practice developed over time, and most importantly, binding interpretations from the FSCD.
Can you give us an example of how the Cassation Division bridged this gap?
Absolutely. The interpretation in Volume 21, Case No. 133-200, is critical. It basically lays out the principles for confirming a country's judicial jurisdiction, creating a judicial framework where the legislature has been silent. It really emphasizes the need to establish a sufficient link or nexus between the dispute and the Ethiopian forum.
Okay, before we get to the grounds for that, let's quickly distinguish the two types of judicial action because they determine how jurisdiction is exercised. In personam versus in rem.
In personam, literally over the person is your typical lawsuit.
Yeah.
It's brought against a person or a company. The relief you want is personal money in order to do something. The judgment only determines the rights between the two litigants.
And in rem.
And rem is over the thing. It's brought against the property itself. Think of a suit to establish title to land. The judgment is declaratory. It settles the destiny of that property, not just between the parties, but against the entire world.
That clarity helps. So let's focus on the three grounds that grant Ethiopian courts in personam judicial jurisdiction.
The first, and most fundamental, relies on the defendant's connection to the state, nationality or domiciliary of the defendant.
And we only care about the defendant's status here, right? The plaintiff's status doesn't matter.
Precisely. The plaintiff could be stateless. The case could have arisen in New York. But if the defendant is an Ethiopian national or a foreign national who's domiciled in Ethiopia, our courts have inherent judicial jurisdiction over them.
And how are those statuses defined?
Nationality is pretty straightforward. But domiciliary is more complex. It's not just physical presence. It requires intent. The Civil Code defines domicile as the place where someone has established the principal seat of their business and interests with the intention of residing there permanently or indefinitely.
And what about foreign companies? If a big multinational is sued here, how is their judicial jurisdiction determined?
Well, generally, a company is subject to the courts of the state that created it. However, the Civil Code has a crucial exception. A foreign corporate body is subject to Ethiopian courts for any lawsuits that arise from activities carried out within Ethiopia. They can't just hide behind their German or U.S. incorporation if the dispute is about their local operations.
Okay, so that's the first ground. What's the second?
The second ground is the doing of an act in Ethiopia.
So this applies regardless of the defendant's nationality or where they live.
Exactly. If the civil wrong, the transaction, the cause of the suit, if it occurred within Ethiopia, our courts can assert jurisdiction.
Give us a specific example that brings this to life.
Okay, imagine a Brazilian shipping company, not domiciled or incorporated here, contracts with an Ethiopian company. The goods get damaged during the transportation leg inside Ethiopia. Even though the company is Brazilian, the damaging act happened here. An Ethiopian court would have judicial jurisdiction.
And there's case law on this.
There is. The Cassation Division confirmed this reach in Volume 10, case number 42928. It ruled that a foreign commercial organization, even if not registered here, can be sued if the damaging act occurred while they were operating in Ethiopia. The core test is whether the transaction has sufficient contact with the territory.
Okay, and the third ground is based on waiver, consent of parties.
This is a safety net. If the first two grounds are missing, a defendant can still submit to Ethiopian jurisdiction by consenting. As we said before, consent can't create material jurisdiction, but it can absolutely validate judicial jurisdiction over a foreign defendant.
How does that consent happen in practice?
It can be expressed like a contract clause that says, all disputes will be heard by Ethiopian courts. That's clear. But what's more tactically interesting is implied consent.
Tell us about implied consent.
Okay.
This sounds like a trap for an unwary defense lawyer.
It is a huge trap. Implied consent happens when a foreign defendant is sued, but instead of raising a preliminary objection to jurisdiction, they just start defending the case on the merits. By doing that, they are deemed to have consented. A lawyer has to make a special appearance, appearing only to contest jurisdiction. If they start arguing about the facts of the case, they've forfeited the objection.
Wow, that's a massive tactical consideration. What about the other way around? Can parties agree to remove jurisdiction from an Ethiopian court?
This is where we hit the limits of party autonomy. If parties agree that disputes must be heard exclusively in, say, Singapore, an Ethiopian court has to assess if enforcing that clause is contrary to Ethiopia's national interest or public policy.
And without a codified law, that assessment must be pretty subjective.
It is. The court has immense discretion. If the case involves national resources or a vulnerable Ethiopian consumer who could never afford to litigate in Singapore, the court may just disregard the clause and keep the case here.
Okay, and just to close the loop, what about in rem judicial jurisdiction?
That one's simple, and it's immutable. It is determined exclusively by the ceders of property. If the land is in Ethiopia, only Ethiopian courts can determine its title. End of story.
So we've established that Ethiopia has competence. Now we move inside the country to the internal allocation of power, material jurisdiction.
Right. Material jurisdiction is about the boundaries of power within the state. It asks three questions. Is this dispute even fit for ordinary courts? Is it federal or state business? And which specific level of court is competent to handle it?
Let's start with what's excluded. What matters are non-justiciable by ordinary courts?
Well, first, matters delegated exclusively to those quasi-judicial tribunals we talked about earlier. The case has to be heard there first.
Can you give us that classic example about property appeals?
Sure. The Cassation Division, in Volume 6, case number 30704, clarified that disputes about property taken under certain old proclamations or claims about government housing have to go to the privatization agency first. A regular court just doesn't have that initial material jurisdiction.
Okay, what else is excluded?
Personal and family matters for Muslims, which are typically for Sharia courts. Disputes that have been settled by a valid arbitration agreement. And finally, purely political or high-level administrative decisions are usually deemed non-justiciable.
So after we clear that hurdle, we get to the horizontal division, federal versus regional.
This is where the tension of federalism really plays out. The operational blueprint for this is the Federal Court's Proclamation number 1234, 202, and 201. And it grips federal jurisdiction into four big categories.
Okay, category 1 is the status of the law.
Right. If the case involves interpreting the federal constitution, any federal law, or an international treaty, then federal courts have jurisdiction. And a huge recent development here is Article 3.2, which specifically empowers federal courts to interpret and enforce human rights provisions of the Constitution. That's a big deal.
So it gives federal courts a clear primary role in human rights enforcement. What's category 2?
Category 2 is the status of the parties. Here, who is involved matters more than the law itself.
So the identity of the litigant pulls the case into the federal system.
Correct. We're talking about cases involving foreign ambassadors, international organizations, the federal government itself, and most importantly, interregional disputes.
So if two private individuals are in a contract dispute using a state-level law, but one lives in Oromia and the other lives in Addis Ababa.
It goes to federal court. The residential status creates a nexus that requires federal adjudication to ensure neutrality.
Okay, category 3.
Category 3 is based on the place where the case arose. It's a geographic override. Any dispute arising within the boundaries of Addis Ababa or Dire Dawa automatically falls under federal court competence.
And the final category 4 covers the nature or type of suit.
Right, these are subjects that are just inherently federal and require uniformity. Private international law, enforcing foreign judgments, nationality, bankruptcy, negotiable instruments, insurance, and all intellectual property patents, copyrights, all of it.
Got it. So once we've figured out if it's federal or state, we move to the vertical division, which level of court is competent. The guiding rule here is efficiency, right? CTC Article 12.1.
Exactly. Every suit shall be instituted in the court of the lowest grade competent to try it. It keeps higher courts from getting clogged with simple disputes. And this vertical division relies on two main criteria: pecuniary jurisdiction, which is the amount in controversy, and exclusive jurisdiction, the type of case.
Let's start with the pecuniary jurisdiction, the money. How does the federal system set its limits?
The federal split is clean and generous. The federal high court has first instance jurisdiction over federal civil cases where the amount is more than 10 million birr.
And below that?
The federal first instance court handles federal civil cases where the amount is 10 million birr or less. Simple.
Okay, simple enough. But now we come to the real complexity that every law student must appreciate: the massive variance in state court pecuniary limits.
This cannot be overstated. Your entire litigation strategy changes depending on the region. Let's look at two prime examples from the source material. In the Oromia regional state, the district courts handle movable property cases up to 1 million birr and immovable property up to 3 million birr.
3 million birr for immovable property is a pretty substantial limit for a court of first instance.
Now contrast that with the limits in the Amhara National Regional State. There, the Wareda courts only hear cases involving movable property up to 50,000 birr and immovable property up to 100,000 birr.
Wait, 100,000? That's a staggering disparity. Amhara's limit for immovable property is 30 times lower than Oromia's.
It is. So think about it. If you're litigating a 1.5 million birr immovable property case in Oromia, you're in the district court. But if you're litigating the identical case in Amhara, you have to bypass the Wareda court entirely and go straight to the state high court.
Which has huge implications for court fees, the appeals process, everything. It really forces a lawyer to commit these specific regional proclamation rules to memory.
You can't rely on the federal limit or the old CPC rules.
Yeah.
It would be a fatal error.
Okay, now for the second vertical criterion: exclusive jurisdiction, where the case type dictates the court level, regardless of the amount.
At the federal level, this is simple. The federal high court has exclusive first instance jurisdiction over those complex categories we listed earlier: private international law, bankruptcy, and so on.
The trickier area is the state level. The CPC originally gave state high courts a long list of exclusive matters in Article 15.2. Is that list still relevant?
That list is now largely historical. It included things like negotiable instruments, insurance, patents, copyright.
But those have all been federalized now.
Exactly. Proclamation 1234/2021 has moved most of those subjects to the federal high court. This means a state high court's exclusive first instance jurisdiction has been significantly curtailed. They mostly retain power over purely regional complex matters, like the dissolution of regional corporate bodies or liability of regional officials.
And what's the consequence if a claim is filed in a court that lacks material jurisdiction?
It is non-waivable, and it is fatal. The court shall reject the claim. Unlike local jurisdiction, the court has to address this on its own motion, even if nobody objects. It's a fundamental defect that just voids any judgment.
All right, so after all that, we come to the final layer: local jurisdiction or territorial limits.
Right. Once judicial and material competence are confirmed, we address this last layer. This is about choosing between, say, the Addis Ababa FFIC and the Bahir Dar FFIC.
The goal here is just pure pragmatism, right? Convenience for the parties and preventing manipulative forum shopping.
That's all it is. And the default setting is in CPC Article 19. Local jurisdiction lies in the place where the defendant actually resides or carries on business or personally works for gain.
And why the focus on the defendant?
Because the defendant is the one being compelled into the process. The law assumes it's most convenient for them to defend the suit where they live or work.
Let's look at the key special rules that can override that. What about a non-resident defendant?
Article 20 gives the plaintiff flexibility. If the defendant isn't resident or doing business in Ethiopia, the plaintiff may institute the suit in any Ethiopian court they choose.
But there's a big exception to that choice for property.
Yes. If the suit relates to immovable property in Ethiopia, the situs rule dominates. The suit must be where the property is located. No exceptions.
And suits against the government actually flip the principle, don't they?
They do. They favor the plaintiff's convenience. If the government is the defendant, local jurisdiction is determined by the plaintiff's residence or place of work. The rationale is that the government can defend itself anywhere.
Okay, what about contracts? They seem complex.
The primary rule for general contracts is that the suit may be instituted where the contract was made or where it was to be performed. Maybe gives the plaintiff discretion. But for something specific, like contracts of carriage by air, the suit shall be instituted only at the carrier's domicile, principal place of business, or destination. The plaintiff loses their discretion there.
And the most unyielding rule of all seems to be Article 25, for suits involving immovable property.
That is a situs rule, and it is absolute. Suits for recovery, partition, or compensation for wrong done to immovable property must be instituted where the property is physically located. It overrides every other rule.
And what happens if you file in the wrong territory? How is a lack of local jurisdiction different from a lack of material jurisdiction?
Well, the claim shall be rejected. But the crucial difference is that an objection to local jurisdiction must be raised by a party. If no one objects, the court proceeds, and the judgment is valid. It will only be invalidated on appeal if the error caused a failure of justice. It shows local jurisdiction is about convenience, not fundamental power.
Okay, so that brings us to the procedural safeguards for fairness. What happens when a court has jurisdiction, but a fair trial still seems unlikely?
This is where we talk about change of venue and removal of judges.
And a change of venue isn't about challenging jurisdiction, right? It's about moving a case from one competent court to another.
Exactly. It moves a case from a court that is locally competent to another that is materially competent, even if that second court lacks the original local jurisdiction.
Who can apply for that and when?
Either party can apply, or the court can do it on its own motion. The application has to go to a higher court, like the federal high court, and the timing is non-negotiable. It must be done at any time before evidence is taken.
And what are the grounds for it? They must be pretty compelling.
They are. First, that a fair and impartial trial just can't happen in the current venue, maybe due to local prejudice. Second, the case involves questions of law of unusual difficulty. And third is the practical concept of forum non-convenient.
Which is when the current court is just found to be incredibly inconvenient for the demanding party.
Right. It's about the defendant's insurmountable hardship. If defending the suit is unreasonably costly or makes it impossible to gather evidence, the court can transfer the case to a more convenient location. It's about balancing rights.
Now, what about the personal side of fairness? Withdrawal or removal of a judge?
This addresses personal conflicts of interest. The goal is absolute impartiality.
And what compels a judge to step aside?
The grounds are comprehensive. If the judge is related to a party or a lawyer, if they've previously acted as a lawyer or mediator in the same dispute, if they have a separate case pending with one of the parties.
And there's a catch-all, isn't there?
Yes, a judge can also withdraw for any other sufficient reason that will bring in justice. It allows for self-recusal when a conflict exists that isn't neatly listed but still compromises fairness.
Okay, finally, let's look at how the CPC manages conflicts of jurisdiction when multiple courts might claim power over the same thing.
Right, there are three classic scenarios. 1, 2 or more courts assume jurisdiction. 2, 2 or more courts both reject jurisdiction. And 3, parties file separate suits from a single cause of action in different courts.
And the CPC resolves these with rules of priority, pendency, and consolidation. Let's start with priority.
That's CPC Article 7. It says if the same cause of action is filed in multiple competent courts, the court where the suit was filed first in time gets priority. The second suit shall be dismissed.
And next, pendency.
This is Article 8. It prevents the parallel hearing of the same issue. It says, no court shall try any suit where the matter is directly and substantially an issue in a previously instituted suit between the same parties in another Ethiopian court. The second court has to wait.
What's the critical exception here? Does this apply if the first case was filed in a foreign court?
It does not. An Ethiopian court is not prevented from hearing a case that is also pending in a foreign court.
And lastly, consolidation of suits.
This is just about judicial efficiency. It's used when 2 or more pending suits involve the same or similar questions of law or fact. If the suits are in different courts, a party has to apply to the High Court or Supreme Court to have them consolidated.
So we've completed a pretty comprehensive tour of the Ethiopian judicial system, from the constitutional structure right down to the specific articles. We established that the whole thing rests on jurisdiction as power.
We did, and we defined the three essential stages of inquiry. Judicial jurisdiction: does Ethiopia have international competence? Then, material jurisdiction: is it federal or state, in which grade of court? And finally, local jurisdiction: which specific venue is territorially convenient.
And it seems like the federal court's proclamation 1234/2021 has brought a lot of clarity to the federal sphere, but the system's decentralization creates these complex pockets of non-uniformity.
And our final thought for you, the law student, should really center on this professional challenge: the profound disparity in pecuniary jurisdiction across regional courts. That 100,000 birr immovable property limit in Amhara versus the 3 million birr limit in Oromia means jurisdictional competency is dynamic. A single lawyer operating across regions has to master a whole patchwork of regional proclamations.
So given that the CPC's original rules have been so overtaken by federal law, how essential is it for the judiciary to conduct a review to harmonize what's left? I mean, if pecuniary limits can vary so drastically, how can lawyers ensure predictable strategic planning for clients? That really is the puzzle that lies ahead of you.
We really urge you to take these insights and go cross-reference the cited legal provisions, Proc 1234/10-21, the CPC articles in those cassation cases, to see this legal architecture in print. Master the power, and you master the profession.
On that note, we conclude this deep dive. Thank you for joining us. We wish you success in your studies.